I'm Lynn Liu, and I'm one of the co-chairs of the Asian Student Caucus here at the Kennedy School of Government. I would like to welcome everyone here tonight on behalf of the following groups who have worked very hard and who have funded our event to make this event possible. They're the Asian Student Caucus of the Kennedy School of Government, the Asian American Law Students Association of Harvard Law School, the undergraduate Harvard-Radcliffe Asian American Association, the Kennedy School Student Government, and the Institute of Politics. Our panel discussion tonight is entitled Redress and Reparations for Japanese Americans, a Constitutional Issue for All Americans. This is the second part of a two-part symposium discussing the salient issues of the Japanese American internment experiences. This afternoon at the law school, a panel discussed the Supreme Court decisions which legitimize the constitutionality of internment of Japanese Americans during World War II, and the current legal efforts to overturn those decisions made 44 years ago. We would like to recognize these afternoon's panelists who are here tonight, too. They are Gordon Hirabayashi, who's principal in the U.S. versus Hirabayashi Supreme Court decision in 1943. Dale Minami, the lead counsel for the Coram Nobis cases, the case of Fred Korematsu, principal in the U.S. versus Korematsu Supreme Court case of 1944. Aiko Herzig Yoshinaga of the National Council for Japanese American Redress. Judge William Maritani, who is also our moderator here this evening. Tonight's panel will focus on the legislative debate over whether redress and reparations should be granted to Japanese Americans who were interned. On September 17, 1987, the U.S. House of Representatives passed a bill offering a national apology as well as $20,000 in monetary reparation for the surviving internees. The companion Senate bill awaits a final vote of passage with 76 current Senate co-sponsors. However, President Reagan has promised to veto any bill that provides any economic reparations. We feel this issue is especially appropriate for discussion during the bicentennial of the United States Constitution. This is indeed a constitutional issue for all Americans who value democracy and due process rights. Our panelists will be able to flesh out these ideas in their respective presentations. Our distinguished moderator this evening is Judge William Maritani. He was a judge with the Court of Common Pleas in the Commonwealth of Pennsylvania from 1975 to 1986. A member of the Presidential Appointed Commission on Wartime Relocation and Internment of civilians in 1980, and a lieutenant in the U.S. Army's military intelligence from 1944 to 1947. He also spent 6 months in 1942 in the Tule Lake U.S. concentration camp in California. Judge Maritani is currently counsel to the firm of Dilworth, Paxson, Kalish, and Kaufman in Philadelphia, Pennsylvania. Without further delay, please join me in welcoming Judge William Maritani.
Thank you very much. The format tonight will be my briefly giving you an outline of what transpired so that you will have a background. I want to tell you that I'm pinch hitting. Angus Macbeth, who is counsel to the Commission on Wartime Relocation, was not able to make it tonight, and when I arrived here this afternoon, I was told that I would pinch hit for him, so you forgive me if I stumble around a little bit. After that, I will then introduce Congressman Mineta, and then followed by Congressman Shumway and Grace Uehara, and we will then open it up for questions. In 1941, upon the outbreak of the war, there was immediately an FBI sweep of the Japanese American community along the Pacific coast. Taken were all the leaders of the community. When I say leaders, president of a business association, all the Buddhist priests, if you happen to be a man of the cloth, but of the Buddhist faith, you were hauled away. On February 19 of 1942, the executive branch got involved immediately with President Franklin Delano Roosevelt issuing Executive Order 9066. Under this order, he authorized the Secretary of War and the military commanders, whomever he may designate, and the military commanders below them that designated by the military commander, to exercise discretion. And the executive order uses precisely that word, discretion, to do whatever's necessary, and of course it goes on about safeguarding military, etc., etc. Under the terms of that executive order, Lieutenant General John L. DeWitt, the Western Commander along the Pacific Coast, then issued orders, number one, placing a curfew. This was shortly followed by travel restrictions, and I want to come back and touch upon those very briefly, and ultimately resulted in the uprooting of some 15,000 Japanese Americans and their parents. Let me come back to the curfew and the travel restriction. All of these restrictions were confined to Japanese Americans. They were not utilized against Italian aliens and German aliens. I, as an American who happen to be of Japanese ancestry, and proudly so, as anyone should be proud of whatever ancestry you happen to be in. After all, this is what the good Lord selected, and who's to argue with the good Lord's selection? Was hauled in for committing absolutely nothing. Now, let me move on to the travel restriction. Very clever. They froze you in place so that you could not move, you could not leave. Now, there came a point, however, they opened up the gates and they said, now we're going to put you in camps. Those of you, quote, voluntarily want to leave the Pacific Coast can do so. And a number of them seized the opportunity and did go into the interior. I do not call that voluntary. I think that's under compulsion, without doubt. Ultimately, on the basis of 1 week's notice, suddenly around in the community, there blossomed posters tacked up. All Japanese to report on such and such a date, and to come with your luggage, only what you can carry in your hands, and to leave. Where, you are not told. How long, you are not told. Why, you are not told. What about your home, you were not told. I was not asked, I happened to be a teenager at that time. What about my bicycle, my treasured bicycle? Not told. What about the furniture? Not told. What about the crops that you have? And this is in the spring of 1942. What about the farmer's crops? Not told. What about your stock in stores? You're not told. You do whatever you have to do. You show up 1 week from today, and you're going. And so it happened that about 110,000, 115,000 Japanese Americans and their parents were hauled off into ultimately 10 separate barbed wire camps in the hinterlands generally. They were placed in desolate areas. The area was surrounded by barbed wire, guarded by armed guards, searchlights in most of the camps. They had guard towers armed with machine guns up there with searchlights. And there was testimony that anytime you have to go from the barracks, you lived in a barracks, you've seen these army tar paper shack barracks. There were 5 families in those barracks with a divider that did not go up all the way up to the ceiling, so you lacked absolute privacy. The great pride of the Japanese American community, of community family cohesion, was destroyed. No longer did we sit down with a family at the dinner table where the father presided and set forth down the edicts, and if you stepped out of line, he told you. You now marched off willy-nilly to a central mess hall as you can, when you can. You also had a central latrine, and you washed and showered there. The entire fabric of the family was utterly destroyed, not to mention the community. Well, there were a few people, at least 3, who said, I'm not going. I'm an American. I don't see why I have to suffer a curfew. I have to suffer a travel restriction. I am locked into place so that I cannot move, when all other Americans who are not of Japanese ancestry are free to move. And Gordon Hirabayashi, who's seated here, was one of them. He was arrested, as Min Yasui also, and Fred Korematsu, and I'll refer to those very briefly a little later. They decided this was America, a land of laws. And those laws are sanctified in the Bill of Rights. And if they mean anything, they ought to mean something now. This is not a jaywalking offense. We are being charged with disloyalty. And by the way, there was no evidence of any disloyalty or sabotage on the part of any Japanese Americans. As a matter of fact, Franklin Delano Roosevelt, J. Edgar Hoover, head of the FBI, was opposed to the uprooting. He said there was no need for it. And so people such as Gordon Hirabayashi says, I'm not going. I'm an American. And he stood on his rights. They arrested him. He was convicted. He said it was a half-day trial in a federal court. And off he went to serve his time. For what? For what? Also similarly with Minya Sui and Fred Korematsu. Now this is a land of laws, and although the trial court and although the authorities may make mistakes, surely when you go to the Citadel in Washington, D.C., the United States Supreme Court, surely they will uphold the law. And when Gordon and Minya Sui took their case ultimately up to the Supreme Court of the United States by a unanimous decision, and as I recall, the lead opinion for the entire court, for that matter, was written by Justice Black, upholding the action of the government in picking up people and incarcerating them for no charges whatsoever and based upon one criterion and one criterion alone: race, an anathema to our democratic way of life. Let me move on. In 1980, the President of the Congress and the President established a Commission on Wartime Relocation and Internment of Civilians, and 9 members were appointed to that commission. 3 by the President, 3 by the Senate Majority Leader, I believe it was, or Senate President, and 3 by the Majority Leader on the House side, and composed of 9 members. The commission then proceeded to hold hearings in 10 cities throughout the United States and in Alaska, and I'll touch very briefly on that. They heard over 700 witnesses either in person or by written testimony. They held hearings in San Francisco, Washington, D.C., Los Angeles, Seattle, Chicago, New York, City of Boston, and also up in Anchorage, Unalaska, and Pribilof Islands. During World War II, the Aleuts who lived along the Aleutian chain and on the Pribilof Islands were indeed evacuated. And I use that term evacuated in its true sense because the Japanese imperial forces had invaded the tip of the Aleutian chain, Attu and Kiska. And of course, the danger was there and they were indeed evacuated. But unfortunately, upon evacuation, they were taken down to the southeastern Alaska and dumped in abandoned canneries and abandoned gold mines. And they were not provided with the essentials of medical care, the food, etc., schooling. And disease was rampant. Many died. And they filed a claim for some sort of reparations, and that was the reason for our hearings up in Alaska. They also asked, incidentally, for return of Attu Island. Of course, the Aleuts had lived in the Aleutian Islands anywhere from 8,000 to 10,000 years. And I don't know when you get to own land, how many thousand years you have to live in the land before you can claim ownership. They had been booted out of there, and they are not permitted to return to Attu. The Commission then issued a report, as they were directed to do, and make whatever recommendations they saw deemed appropriate. And the Commission, by a unanimous decision, ascribed the following 3 factors as to the cause of what happened in 1942 involving the Japanese Americans and their parents, some 115,000 of them. Number 1 was war hysteria. Number 2 was failure of political leadership. And number 3 was racism. Those were the 3 factors. Now, the remedies set forth, recommended by the Commission, were a number of them, but essentially they related to, number 1, an apology by the government. Number 2, a pardon for certain ones of those convicted, such as Gordon, although Gordon has and others have initiated lawsuits to have their convictions overturned. Dale Minami, who's sitting over there, is one of the lead counsel, has been handling, and I believe is still involved in some of those cases because they're not all really completed. And number 3 is redress. Now, in the First Amendment, the Bill of Rights, the First Amendment, in my opinion, is probably the most important amendment in all of the Bill of Rights, because enshrined in the First Amendment are a number of rights that our founding fathers deemed particularly important and critical. Number 1, we all know freedom of speech. Thank goodness in this country we have freedom of speech and of press, of course. Freedom of speech and freedom of the press. Another is freedom of religion. How beautiful and wonderful it is that in this country that we have freedom of religion, that we can worship the one God by whatever means each of us sees fit, as long as we don't tread on other folks. But there is also another right in there that very seldom do we hear about, and even less ever exercise, and that is to petition the government for right of redress. And this is what it's all about. It doesn't say petition the government for an apology, because the founding fathers, if they wanted to say mere apology, they could have said so. They said instead redress. There are presently pending in Congress bills. One has already been passed in the House side, House Bill 442. And those of you who are familiar with the 442nd Regimental Combat Team, the all-Japanese American outfit that fought so valiantly in Europe, know that that's probably where the numbers came from, 442, and indeed you would be right. Incidentally, another 5,000 to 15,000 Japanese Americans served in the Pacific against the common Japanese enemy, Japanese Americans. And on the Senate side, there's Senate Bill 1053. And as indicated earlier, it has a number of sponsors. Over 70 senators have sponsored the bill. And so we are now at this posture at this time. Let me back up and tell you what happened in 1942. I suggest to you it's a rather unique situation in the annals of our history where all 3 branches of the government coalesced, their energies coalesced, to work against one group based upon the anathema of race. The executive by issuing Executive Order 9066. The legislative by passing laws making it a criminal offense not to obey the executive order and all that emanated out of it. Number 3, the judicial branch by sanctioning all of this under a terrible, terrible decision in the Hirabayashi case. So that comes back to today. A matter of honor for this country, our proud nation, my country. We now have the legislative beginning to make amends. The House has already passed a bill. The Senate is about to pass a bill, and I think it will. On the judicial side, a number of quorum nobis cases have been initiated by Gordon, Fred Korematsu, and Min Yasui. May he rest in peace. He's dead now. And all the court decisions, either in whole or in part, have been favorable and said this was a wrong. So at this point, we now have the legislative making amends. We have the judicial making some general amends, although the real true amendment or amending of the wrong would only come about if it goes up to the United States Supreme Court and they make it the law of the land that thou shalt not in this country ever incarcerate people on something terrible as basis of race. But the courts are doing the best they can. Now we have the executive. President Reagan will have the opportunity to restore the luster that belongs to this country, that it may shine proudly. And we'll see what will happen. With that, I'm going to now turn it over to Congressman Norman Mineta from the 14th District of California. The congressman is a member of the Merchant Marine. You're not on Merchant Marine, you're on Public Works and Science and Space. And we will call upon Congressman Mineta to give us some insight on the legislative aspect. Thank you.
Thank you very much, Bill. Before I see Dale leaving, Dale, could I have you just raise your hand so that everyone can see? Dale Minami is the lead counsel on the Quorum Nobis cases. Okay. And I just wanted to make sure that everyone knew who he was, as well as Aiko Yoshinaga Herzig. Aiko, please. These are people who have been active in this whole redress area, and I think ought to be recognized. Gordon Hirabayashi. Gordon, please, if you would also rise. And, of course, you've already met Bill Maritani. Thank you very much, Bill. And it is the 13th Congressional District. My very fine colleague and friend, Norm Shumway, represents the 14th Congressional District. But I am really honored to be able to join this very distinguished panel made up of Norm Shumway as well as Grace O'Hara to discuss the Civil Liberties Act of 1987. I want to congratulate those who have been involved in putting this together, and especially a person whom I've gotten to know real well, Lynn Liu, who you heard from earlier. Earlier last year, or this year, as all of you know, Lynn went to that great citadel of learning, Berkeley, University of California. What's this hissing? And let's hear it from Berkeley. And then she was a staff associate in our office, and I had the good fortune of working for her for about 6 months. And it's amazing how much I learned during that time and how efficiently our office worked. But it is really a great deal of pleasure for me to have this chance to be here. Bill, I want to thank you for the synopsis in presenting the vital and timely topic that we're here to discuss. As all of you are very well aware, Congress is considering the Civil Liberties Act of 1987 in the year that we are celebrating our bicentennial of perhaps the greatest living document that we have ever produced, and that is the Constitution of the United States of America. Consequently, our actions could be no more appropriate, the timing no more germane, than to have really this legislation being considered in the context of the embodiment of our Constitution 200 years young. The Act, Civil Liberties Act of 1987, H.R. 442, may not deal with events either as distant or as proud as those in Philadelphia 200 years ago, but the bill does address events just as central and just as fundamental to our rights and to our laws. And now, after 45 years, Congress has the opportunity to close the book on one of the most shameful events in the history of our country, and that is the internment of some 120,000 loyal Americans of Japanese ancestry who, without trial or jury, were imprisoned, born on the basis of wartime hysteria, lack of political leadership, and race hatred. Now, I will leave the discussion of the legislative history of H.R. 442 and the story of the superb grassroots lobbying that went on behind this bill to our very erstwhile and hardworking Grace O'Hara. She is really dynamite. Grace is not only an expert on H.R. 442, but she really has been the real powerhouse behind our recent success in the House of Representatives. The depth of the injustice, the responsibility to acknowledge and redress the wrongs, these will be the points that I would like to focus upon, for these facets still constitute a stain on our nation's legacy. Remedies. What possible remedies could there be for such grievous wrongs? In truth, we simply cannot debate the remedies for summaries stripping away the rights and dignity of 120,000 Americans unless we first understand the complete tragedy of the government's policies policies which led to the needless injustice which the evacuation and internment represented. As Bill has outlined, beginning in 1942, the federal government ordered and sent 120,000 Americans of Japanese ancestry to isolated camps scattered throughout the western United States. Those who were interned and evacuated had but days, in some cases only hours, to dispose of their properties and set their affairs in order. And then, carrying only what their arms could carry, these Americans were summarily shipped off to parts unknown for up to 3 years. Because the government of the United States was responsible for the violation of 120,000 lives, that government, our government, has a legal and moral responsibility to compensate the internees for the abrogation of their civil and constitutional and human rights. Congress began this process of national reconciliation with the creation in 1980 of the Commission on Wartime Relocation and Internment of Civilians. But I will leave it to Bill, as he has already shared with you his great expertise on the work of the Commission and their findings. In brief, then, the Commission found that the evacuation and internment was indeed the result of racism, war hysteria, and a failure of political leadership. The Commission found no military necessity for the internment. J. Edgar Hoover, the director of the FBI, saw no justification for the internment. War Department documents, classified until the Commission's investigation, also showed that military authorities knew that there was no military necessity for internment. It is a point of historical fact. No citizens or resident aliens of Japanese ancestry were ever charged or convicted of treason or espionage. It was only appropriate then that the Commission, following their exhaustive study, recommended appropriate remedies for the injustices of the internment, and those recommendations are the basis of H.R. 442. The internment was not a mere inconvenience, as a few sad apologists have contended. Evacuated with little notice, thousands of Americans lost their homes, lost their businesses, and lost their farms. And we lost nearly 3 years of our lives. And although the financial losses were enormous, the losses of friends, evacuation opportunity, and most importantly, standing in our communities became, in terms of loss, incalculable. One night in early 1942, when we did not know what events were to come, my father called the family together and he said that he did not know what the war would bring to my mother or to him, since they were prohibited by racial exclusion laws from becoming citizens. But he was confident that his beloved country would guarantee and protect the rights of his children, American citizens all. But his confidence, as it turned out, was misplaced. I was born in this country, as were most of those who were interned, and yet at that time, even citizenship was not enough if your parents or grandparents had come from Japan. And so, without a trial, accused only because of our ancestry, we were all to be sent away from our homes. In our case, to a racetrack called Santa Anita, then to some tar paper barracks in Hart Mountain, Wyoming. And I was 10.5 years old at that time. And my friend, and I consider him a friend and good colleague, Norm Shumway, who is with us this evening, once wrote in a letter, and I quote, "If, like me, you are a member of Congress well known for your love of Japan, its people, its culture, even its language, opposition to the measure, redress, will raise more than a few eyebrows among your many Japanese friends. End of quote. In my mind, Mr. Shumway's letter stands not as a mere disagreement over an issue, rather as a fundamental misunderstanding of the issue itself. The issue of redress has nothing to do with his, quote, Japanese friends, unquote, but has everything to do with his American friends, with his American constituents, and the system of government of the United States of America. Quite simply, it is a serious logical, historical, and political error to in any way associate the actions, beliefs, or loyalty of Americans who happen to be of Japanese ancestry with the nation of Japan. The evacuation and internment had nothing to do with the acts of any other nation. They had everything to do, however, with the government of the United States and how that government treated its own citizens. And it is quite clear in this case, the United States government did not heed the Bill of Rights when it evacuated and interned 120,000 loyal Americans. Now, this point becomes crystal clear when we remember that no Americans whose ancestors had either immigrated from Germany or Italy were rounded up and interned en masse. And yet we were at war with those nations too, and it is another historical point of fact. That is that the evacuation order referred only to aliens and non-aliens of Japanese ancestry. Who are non-aliens? They couldn't even use the word citizens. And so they say aliens and non-aliens. And our race was the sole deterrent of our fate. And so it was that on the 29th of May, 1942, without a trial, without being charged or convicted of any wrong, my family was ordered to board a train under armed guard, which took us from our home in San Jose, California, to an unknown distant barracks. We were first sent, as I said, to Santa Anita Racetrack. We showered in the horse paddocks. Some families lived in converted stables, others in hastily brought together built barracks. And we were then moved to Heart Mountain, Wyoming, where our entire family lived in one small room of a crude tar paper barrack. What I had done, and what had the others who were interned done to deserve prison? Murderers, arsonists, even assassins get trials, but not young Americans born and raised in San Jose, California, and in the other parts of the United States who happen to grow up being born of a certain race. And our mistreatment was a cavalier denial of rights that we were forced to endure, and not something that I believe that our founders had envisioned or had in mind when they wrote our great Constitution. Some would say that it is too late, that we should not second-guess the past, that people today cannot understand the hysteria of the time. But if we did not examine our history, if we did not judge the past with the knowledge of the present, then we condemn our present and future heirs to repeat the follies we commit. A wise nation, our nation, knows that if we are to have a future, we must revel in our days of pride and recognize our days of shame. Our nation was scared, true, but is fear, be it founded or in the case of the wholly misguided evacuation internment, unfounded, ever a reason to crush the very freedoms for which we fight? Show me the fine print in our Constitution which warns, not valid when the going gets tough. Now, some say that the internment was for our own protection. If that is the case, then why were the machine guns pointed in at us? from the guard towers perched high above the barbed wire fence. Besides, we all know that under our criminal justice system, we protect, not imprison, individuals should their physical safety be threatened. Well, I see that my time has come to a close, but I would like to just say that many people are supportive of the bill, and there are some costs involved, and many people are concerned about those. And maybe during the course of the question and answer period, we can get into that area about it. But it seems to me that it is obvious that a vile precedent would be affirmed if the Congress does not act. We will be supporting the precedent that our government is free to round up its citizens on the knee-jerk basis of race, hysteria, and suspicion. And we will then have said to the American people and to the world that the Bill of Rights can be suspended at will and for the sake of expedient jingoism. In short, if we do not refute the shame of the internment, then the specter of this tragedy will resurface just as surely as I am standing here before you, and the injustices will recur. We know that that's a possibility because of the document that we have already uncovered that exists within the Department of Justice that calls for the evacuation and internment of a certain racial group or ethnic group right now. So again, I appreciate this opportunity to be here, and we'll get into some of the other issues during the question and answer. Thank you very, very much.
We now come further to addressing the matter of redress under the First Amendment, and there can be differing views or differing perspectives of what those remedies ought to be. We will now hear from Congressman Norman Shumway, who is from the 14th District, that's Stockton, generally the Stockton area. Congressman Shumway is on the Banking and Finance and Fisheries Committee, aren't you? Merchant Marine. Thank you very much. Would you welcome Congressman Shumway?
Thank you, Judge Maritani, and ladies and gentlemen, it's a distinct pleasure for me to be here tonight and serve on this panel. I want you to know at the outset that I have great esteem for my colleague Norman Mineta. We sit on opposite sides of the aisle, but I've worked with this gentleman for some 9 years in Congress, and I have a great deal of respect for his ability, and I'm pleased to be here with him tonight. And Norm, I will exact no promise or endorsement from you in return for that. I'm also delighted to be with Grace Uehara, who prior to her internment grew up in my hometown of Stockton, California, and so likewise has status as an old friend. There are many friends, Americans of Japanese descent, who have worked very hard on this measure, have pushed it to the point where it is today, and I respect their efforts. In fact, during the years that I have served in the House of Representatives, I have represented the areas of California where two of these camps are located, Manzanar and Tule Lake. I visited those sites, and I've seen the cement foundations of what were the tar paper barracks that Judge Maritani described. I've seen how bleak and stark the environment was where the camps are located. And in spite of my position on this bill, I have a great deal of empathy for those who were subjected to that kind of internment and now feel so very strongly that they should be given the apology contained in this bill and the redress which the bill provides for. In one respect, as sitting at this table and knowing how the other participants on the panel feel about the issue, I suppose I am a thorn among roses, but we should all realize that in this great country of ours and in the guarantees so well described by Judge Maritani, we do have the freedom and indeed, I think, a responsibility to speak out and to share our thoughts, and this is what we do on a daily basis in the House of Representatives. So I'm going to present the other side of the coin, and it's not because I don't have respect for these people or their position, but it's because I think there are some arguments that need to be made of a different nature. Certainly, the forced evacuation of American citizens was a very bleak and unsavory chapter in the history of this country. I think, though, that H.R. 442, as we debated it in the House, is not the right answer. It's a bill that is highly suffused with emotion and has as its basis emotional arguments rather than reason. I think it would establish a very dangerous precedent, one which would assess the actions of the past by the standards of the present. And perhaps worst of all, it seems to me that this measure may well invite a great wave of anti-Japanese, Japanese-American hostility. Unjustified, to be sure, but nevertheless one which I think will be forthcoming. When the executive order, followed by a congressional enactment, was issued in 1942, and the forced evacuation of these American citizens and some non-citizens began, there were several judicial actions contesting various aspects of the government's authority to proceed with this kind of activity. 3 of those actions went to the Supreme Court, and perhaps the best known among them is the Korematsu case, likewise the Hirabayashi case. But in the Korematsu case, which was decided not by a unanimous court, but by a 6-3 decision, Justice Black said, "We cannot, by availing ourselves of the calm perspective of hindsight, now say that these actions were unjustified." The court no doubt considered these actions by wartime leaders in their context, and there's no doubt that there were some very extraordinary social forces at work in the early stages of World War II. But the point is, those 3 cases essentially upheld the exclusion of Japanese to prevent sabotage and espionage, which were the reasons given at the time. The Hirabayashi case upheld the discriminate curfew applied only against those of Japanese ancestry. And I know my friends at the table here will very aptly point out that none of these cases squarely ruled on the constitutionality of the War Powers Act, and therefore they don't legally condone the actions that are now criticized. It must be kept in mind, though, I think, that the many courts considering these cases had ample opportunity to condemn the relocation program, and yet did not do so. Those pronouncements, called dicta, are commonplace in written legal decisions, and because of the absence of such dicta in these cases, legal scholars for years have considered these cases as evidence that the actions in question were indeed sanctioned at the time. And it's important to remember the words "at the time." Now we are, almost 45 years later, attempting to go back and evaluate the actions of the government and applying current standards as we do so. We have been the beneficiaries of an enhanced sensitivity regarding human rights and civil rights. And the way we interpret those guarantees of the Constitution in this year, 1987, is different from the way we interpreted them 40 years ago. And I think that to apply the standards of today, which are newly refined and perhaps higher than they were in the past, to actions of the past really is something that we should not be doing socially, nor do I think there is the legal precedent that would justify Congress doing that in H.R. 442. If there were such legal precedent, and if this bill indeed becomes law, then I suppose we should consider compensating pre-Miranda rights arrestees because they did not hear their rights read to them before they were prosecuted. Nowadays, the Fourth Amendment would require such a reading under the concept of search and seizure. Carrying that thought one step further, I suppose we should consider compensating school children who were the victims of separate but equal policies prior to the Supreme Court decision in 1954, Brown versus Board of Education? Or how about inmates who were kept in prisons such as Alcatraz, chained in dungeons in some cases, prior to the advent of penal reform? That kind of conduct now would be outlawed by the Eighth Amendment as cruel and unusual punishment. But years ago, when Alcatraz was a functioning prison, it was not thought to be so. All of these cases have a couple of things in common. One is that they describe activity that was legal or justified at the time. And second, that activity was a result of government action. And perhaps third, that activity as we now see it resulted in a deprivation of constitutional rights. It seems to me that we make a mistake when we go back and try to judge the actions of history by the standards of the present. Another problem that I had with this bill was the arbitrary nature of the $20,000 payment for those who were interned. I could find no logic, no reason, no relationship to any identifiable criteria for that figure. It seems to me that that figure therefore defies fair play by awarding the same amount of money to everyone. Some went to camp as infants, some were born in camp and spent perhaps only days behind fences before they were released. Others, by contrast, gave up homes and businesses that they had spent years building, undoubtedly making by far greater sacrifices. I think if fairness is to be a factor, then we should develop some kind of formula that would be reflective of the degree of deprivation experienced. I offered an amendment on the House floor during the consideration of this bill which would provide such a formula. I worked it out just to escape the arbitrary nature of the provisions contained in the bill. Nothing magic about it, but I said for those who were there as adults for 3 years or more, they should be compensated the full $20,000. For those who were there as adults but less than 3 years, they should be compensated at the rate of $18 per day, which over a 3-year period of time just about works out to $20,000. Those who were there not yet adults under the age of 18 should be compensated at the rate of $1 per day times their age. That amendment failed on a voice vote, but I nevertheless thought that it would be a more fair application of the law if indeed we are trying to compensate people for the degree of hardship suffered. I felt that there could be a simple administrative claims procedure devised that would reflect the age and length of stay and provide commensurate compensation and would use the formula that I had offered. Another problem that I saw in this bill dealing with fairness, that is that it provides compensation only to those who were interned who are still alive. There is no testamentary aspect to this compensation. That limitation seems to indicate to me that the purpose of the bill is to enrich the lives of some rather than make amends to all. It seems to me that if the bill is designed to penalize our government for wrongs committed, which has been said its purpose is, then compensation should be made to the heirs of those who were interned and not just the survivors. The government's error was not a contractual error, and it should not be abated by lack of survivability. Another shortcoming I saw in the bill was the division of monies for compensation and education. The bill authorizes $1,250 million. Of that sum, all but $50 million goes to compensation. The $50 million would be used to establish an educational trust fund. Again, it seems to me that if our purpose here is to expiate those wrongs, then the lion's share of this money should go to a trust fund or perhaps an educational endowment fund that would keep be in front of us perpetually the memory of what happened in World War II and the fact that we don't want to repeat that kind of activity in the future. Some of my friends say that this bill is justified because the traditional way that we redress wrongs in America is the award of monetary damages. Judge Maritani knows well there are many cases where legal wrongs have been recognized, but money is not awarded. And I would just cite as examples cases of injunctive relief, cases of declaratory relief, neither of which necessarily requires money damages. And there are cases decided in the spectrum of civil rights violations that provide that kind of relief. Maybe my greatest concern about this bill is the fact that it will, it seems to me, in some respects, be detrimental and demeaning to Japanese Americans. I'm not defending this kind of reaction. Some have misunderstood my saying this as thinking that it would be justified. It's a very biased, it's a very prejudicial kind of reaction. But I think it reflects the kinds of feelings that are out there in the real world. There will be a transfer of that bias from against the Japanese imperial empire to American citizens. Americans of Japanese ancestry have really distinguished themselves. In California, my home state, for example, their wages are about 15% higher than the statewide average. They're good citizens, loyal patriots. They've worked hard raising their families. They've earned the respect and admiration of Americans in general. This bill, I think, could spawn a new and unnecessary and deplorable wave of anti-Japanese bias. And already I'm getting mail from veterans groups and others, again without justification in my view, but nevertheless mail that reflects that kind of bias. There are others who served in Japan during the war as physicians or missionaries or other kinds of churchmen, and likewise they see some degree of resentment here. They feel that resentment because they are not being paid the $20,000. I'm not comparing the two, but I'm only trying to point out the likelihood of that instinctive reaction which I think will prevail. Finally, this measure overlooks the fact that there was a claims procedure that was open for some 10 years between 1949 and 1958, by means of which Japanese American citizens who lost property were able to make claims for their losses. Indeed, some 27,000 claims were paid out. Some $37 million were paid, and that money was to compensate for real and personal property loss. Those claimants that were paid through that procedure received that payment in full discharge of all of their claims and satisfaction, conclusive to all claims as to all claims against the government. So it seems to me that what we have in H.R. 442 is not a good bill. It's a bill that is highly charged of emotional appeal. It applies some very unrealistic standards. I think it is counterproductive in many respects, and I think it reflects typical congressional desires to solve problems by simply throwing money at them. I think if we're really serious about doing something about what we did in World War II, we could make redress in a much more meaningful manner, a much more profound apology, a much more long-lasting educational fund, a much stronger commitment to civil liberties studies and research in the future, and perhaps a very handsome monument that might be a tribute to the fact that we are committing ourselves as a people to not or to not do again what we did with great injustice during World War II. But to put a price tag on the mistakes of the past and to establish a precedent, as this bill will do, seems to me a very unwise solution. It purports to say that a check for $20,000 can somehow erase 4 years or 4 months or even 4 hours of hardship and sacrifice. And I think that that really is not the kind of solution we're looking for. We should be searching for solutions that will honor and preserve the inherent dignity of the Japanese Americans, and indeed, for that matter, of all of us as American citizens. Thank you very much.
Grace K. Uehara is the Japanese American Citizens League Legislative Executive Committee Director in Washington, D.C. Previously, among other things, many things indeed, she was a past National JCL Vice President, and now I'm going to call upon Grace to give us some insight as to the lobbying work involved in getting 442 passed through the House and her plans in terms of the Senate and perhaps the President. Thank you.
Thank you, Judge Maritani, Congressman Mineta, Congressman Shumway, ladies and gentlemen. It is indeed a pleasure for me to have this opportunity to discuss with you this issue on which I have been spending the last 2 years, 7 days a week. And so when Congressman Shumway talked about this issue being suffused with emotion rather than reason, I think I would have to respond that I am proud of the fact that it is suffused with emotion and I can respond to the pain that our people went through. But I think that I can also tie in reason with what I have to say. Actually, Congressman Shumway told you that I was born in Stockton, and I know that Congressman is not a native of Stockton, California. I think you're a transplant. But I was born there and went to school there, and as we talked previously, I was back for my 50th high school reunion this year. And in going back to the reunion, I had traveled the furthest distance, and I met Bill Biddick, who is a judge there, and Leslie Knoll, whose father, Tully Knowles, was the college president when I was a senior at college, at the College of the Pacific before I entered one of the camps. So that I feel that I can talk from real personal experience. And one of the things that concerned me about Congressman Shumway's statement during the voting on H.R. 442 had to do with the fairness factor and particularly the formula. All of us know that that $20,000 is not enough. It is only symbolic payment. We also know, as he talked about the Japanese American Evacuation Claims Act, that that also was not a fair settling and accounting of the losses that our parents and other people suffered. It was primarily for losses, property losses that they could substantiate. And as he said, 27,000 people applied for the payments. Let me tell you that the payments only averaged $400. And during the first 2 years, only several hundred claims were processed out of those 27,000, so that the government had to step up the process because they were spending $1,400 to process each claim. Knowing that, I cannot agree to Congressman Shumway's formula to have the money all expended for some bureaucratic procedure. Later, I think that we'll have opportunity to respond to some of the other issues, and let me just go on with why I'm here and my part of the discussion. I have been assigned the lobbying effort of the Japanese American Citizens League Legislative Education Committee. And I'm going to focus on the legislative strategy and the organization of the two-track program. First, a quick background about JACL, because I think there are people who do not know about the organization, and the decision to seek redress are in order. JCL was founded in 1930 and was to be a civic and patriotic organization concerned with the welfare and political and economic progress of American citizens of Japanese ancestry. And there was a real need because our parents and the older Niseis faced undue racism from the time that Asians came to this country. Prior to World War II, JCL was a West Coast organization which extended to the Intermountain states. Today, it is a national organization of 27,000 members in 114 chapters with 8 districts. Some of those members are in states with no chapters. In 1978, JCL made the decision to pursue redress at the Salt Lake City National Council Convention. The JCL National Redress Committee on March 4, 1975, passed by a vote of 4-2 the plan to seek the establishment of a commission to study the matter of the World War II forcible removal and incarceration of 120,000 Americans. Full inquiry would provide the necessary information to take the redress issue to Congress for its attention and action. Subsequently, JCL conducted a survey on the redress issue within the national organization. And there have been members of Congress, particularly Daniel Lundgren, who has said that the majority of Japanese Americans are not for this issue. Well, let me tell you that there was almost unanimous agreement that we should pursue redress. About 85% of the respondents stated that there should be individual reparations, and a lesser number wanted a trust fund for the general welfare of the community, an educational program to inform the nation about the Japanese American experience. Seeking redress through the legislative process recognizes Congress is a representative body of our government. For an organization with very little political clout, savvy, and money is all uphill work requiring total commitment and perseverance. The two-track program is as follows. The first part is the Nikkei members of Congress, Senators Inoue and Matsunaga and Representatives Mineta and Matsui are our most important and foremost, if I may say, in quotes, lobbyists. The 2 senators fought with the 100th Infantry, and our 2 representatives spent time in camp, so they know what this issue is all about. In the 100th Congress, this outstanding team was enlarged with the addition of Representative Pat Saiki, Republican from Hawaii. Let me say, without the leadership, the committed support, and the consultations so generously given by the Nikkei members, it would have taken twice the time and the resources of JCL and LEC. Without any doubt, these members of Congress are our most important lobbyists. The second part is the grassroots, the constituents and the organizations that impact on the members of Congress. We must remember that these people are elected into office by the people. The redress bills were first introduced in the 98th Congress, 1983-84, late in the first session, so that the actual lobbying was then carried jointly by the Washington office and the headquarter redress staff in the second session of the 98th Congress, and then into the 99th Congress, that was in 1985 and 86, and now we are concluding this month the first session of the 100th Congress. I think I can say at this time, when I told you earlier that most bills take 6 years, that we could be on schedule. I hope we are. Due to the limitation of time, I will discuss briefly the Legislative Education Committee's strategy. This arm was not activated until May of 1985 when the JCL board decided the time had come to give redress the highest priority and to establish a separate lobbying organization to protect JCL's tax-exempt status. When the JCL LEC board met in San Francisco in September of 1985, we had started fundraising in June of 85. We had $40,000. Hardly enough to cover expenses, let alone the salary of a director. Some people have asked me what I actually do. Well, lobbying is really not my profession. I had to learn the hard way. But the program could not wait. The bills had to come out of the subcommittee to which they had been assigned and had stayed through both 98th and 99th Congress. The Washington lobbying had to focus on the House Judiciary Subcommittee on Administrative Law and Government Relations, and the Senate Governmental Affairs Subcommittee on Civil Service, Post Office, and General Services. The grassroots lobbying had to have a nationwide base in order to target on 3/4 of the members of Congress. Both the Washington lobbying and the grassroots lobbying would establish that redress is a constitutional issue, and that was really discussed through today. And it would develop the understanding of the why on the recommended remedies and not other remedies to redress the government's abrogation of the basic constitutional rights of the 120,000 individuals who lost their freedom. For every hearing, our statements would center on those rights and our desire to not only set the record straight, but see that there is fair accounting and correction. It is very important to mention that another major support system was the fact that Japanese American men and women served in the United States Armed Forces, both in the European and Pacific theaters. For those people who say that all people suffer during war, we have had to respond that not all people fought in the war to protect freedom and democracy, but had parents and siblings locked up in compounds behind barbed wires and military towers. And to fight in a war, as I said this afternoon, that is a responsibility of good citizenship. But we are not required as American citizens to spend time imprisoned without any charges. Let me also say that the Magna Carta of 1215 was the inspiration behind the world's most enduring document, the Constitution of the United States. The following words are apropos to redress. No free man shall be taken, outlawed, banished, or in any way destroyed, nor will we proceed against or prosecute him, except by the lawful judgment of his peers and by the law of the land. That's what redress is all about. And I am glad that our Constitution is based on those words, because we are really talking about the failure of our people to have due process. So today, after 5 years of concentrated educational activities, the Japanese American experience, the injustice of the removal, incarceration, and relocation of Japanese Americans, it is conceded by all fair-minded and responsible people and organizations. And it was Barney Frank, who is a representative from this state of Massachusetts, who said to me as the chairman of that subcommittee, he said, "Grace, don't waste your time talking about the constitutional issues, the injustice of the incarceration." He said, "You need to address the payment issue." And so in all of our hearing testimonies, that is exactly what we did. Today also, a review was made on about the April 20th, 1987 statement made by Solicitor General Charles Freed, the Department of Justice, who told the United States Supreme Court in U.S. versus Hori that the evacuation and incarceration of Americans of Japanese ancestry was frankly racist. And so we know that Freed was speaking of the racist rationale most clearly articulated by General John D. Witt, commanding general of the Western Defense Command in 1942. Then 9 days later, on April 29th, 1987, Richard K. Willard, Assistant Attorney General, Civil Division, Department of Justice, testified at the hearing of the Subcommittee on Administrative Law and Government Affairs on H.R. 442, Quote, "It is a long, unsubstantiated further step, however, to brand those actions as a product of racial prejudice or hysteria and a failure of political leadership." When a recess was called by Chairman Barney Frank for a House vote, and this is what happens when you have a hearing, we had to wait until the Chairman Barney Frank came back. I had a dialogue with Mr. Willard and tried to show that he did not dispute the underpinnings of race prejudice and that the forcible removal and incarceration was unjustifiable as a matter of public policy. But I'm telling you all of this just to say that I'm not quite sure that the Justice Department people talk to each other, because there seems to be a lack of communication in the department. We would think there would be outright support for redress if you go by what William Bradford Reynolds of the Justice Department said at Vanderbilt University on May 23rd of 1987. Quote, "Let us never forget that the Constitution in its entirety, the supreme law of the land, and all the branches, the executive, legislative, and judicial, are subordinate to it," unquote. If these words are true, we should not only have the judicial, but the executive and legislative branches all taking the lead in support of redress. And I'm not sure that the president is really going to veto the bill yet. That statement was made by the Office of Management and Budget, and so we are working very hard to make sure that he is informed. I think I'm warned that my time is up, so that I will answer any questions later on. Thank you.
We will, I don't know whether this is on. We'll take some questions, but first of all, I wonder if there are any questions from the panel members to any other panel member.
Well, the only thing I wanted to mention was the fact that it seems that two points I'd like to cover. One is the Evacuation Claims Act. First of all, as I recall, the total amount that was paid under that was about $37 million, and yet the Federal Reserve Bank at that time had estimated the losses to be in excess of $600 million based on the 1942 dollar. And so this legislation is not for the loss of personal property, but is for liquidated damages for the loss of constitutional and human rights. And so we don't have to follow, you either have constitutional rights or you don't. Now, if you follow Mr. Shumway's example, then you get into the bell curve theory of constitutional rights. And that's based on age, and it's based on how many days you spent in camp. And whether you were a 10-year-old kid or an 87-year-old grandmother, you had your constitutional rights abrogated. And so there ought not to be some formula based on a per diem reimbursement for your loss of constitutional rights. In fact, if the complaint is on the basis of 27,000 claims, and how much those claims, as Grace had talked about in terms of average amount paid versus how much an administrative cost that it costs to figure out in administrating the Evacuation Claims Act, just think of what the administrative cost would be in trying to compute Shumway's bell curve theory of restitution on constitutional rights. It may be simple enough to count the birthdays of people who might have suffered time in camp, but I think the administrative cost would be inordinate in trying to compute that. There's no question the $20,000 figure is an arbitrary amount. But remember that both during the civil rights demonstrations as well as the anti-war demonstrations in Washington, D.C., there are cases in which people were compensated amounts of money for their unjust detainment. And so in 1976, a court awarded $35,000 to a man arrested and falsely imprisoned for 6 hours. In 1952, a man was falsely imprisoned for less than a single day and was awarded $50,000. And there was a case involving one that Congressman Dellums brought a suit against the then chief of police of the Capitol Police Department, and in that time got an award for, again, deprivation of constitutional rights, not only of him as a member of Congress, but of his constituents who were there to deliver a petition who were then arrested. There were people who were arrested, over 1,000 people, who were then herded into JFK Stadium and held there as a compound overnight. And they received $10,000 compensation for being detained overnight. And so when you think about the amount that is involved in this bill, compared to what has been compensated for a person's illegal arrest and detainment, then it becomes very, very small. And then when you think about the class action that is also going on through the court system right now, then you know that the potential liability under the Horry case can probably run into the, let's say, the $250 billion mark is what I think I have even heard as a ballpark guess, if that case ever is approved by the Supreme Court. So again, this bill is an adjudication or an adjustment of what the compensation ought to be, and I use the word compensation advisedly because it really is for liquidated damages for abrogation of human and civil rights.
Congressman Shumway, would you like to make any comments on that?
Yes, I would. First of all, let me point out there is no Shumway bell curve theory. If my formula were put on a graph, you would find the one line being a tangent to the baseline. There isn't any curve to it. There's no bell shape to it at all. Let me just say furthermore that in civil rights cases, courts will always evaluate the degree of hardship and wrong that a particular victim has suffered, as in determining the degree of pain and suffering in torts cases. The severity of the suffering, the length of the suffering, all of those things must be determined by the court. If our purpose here is to be fair, then I think fairness would say let's find out who was there the longest and certainly compensate him the most. And if we can do that by a simple formula that would not entail coming in with great body of proof and evidence, which I realize much of that is not available, but by simply indicating one's age, and certainly every one of these claimants has an age, and that fact will be known, and the length of stay in a camp, and certainly that fact is known as well. If we don't have records of the fact that they were in a particular camp for a certain duration, then they may not qualify for payments under the Act even without my amendment. So I submit that the evidence is there. It would not require a great deal of administrative burden on either the claimants or the part of the administration, but I think the end result would be a much more fair one. And finally, let me just say that my objection to this bill does not rest on financial grounds. You will notice that in my presentation I made no reference about the bottom line dollar figure. I would concede that for 4 years of wrongful detention and a clear precedent justifying some compensation for that the amount of $20,000 is insufficient. It really is not my point to attack the amount of money being spent here, nor do I want to let anyone believe that my opposition rests upon some naive misunderstanding of what occurred. I'm simply trying to get away from the arbitrary nature of the figure, provide a more fair measure of compensation in the bill, and perhaps thereby make it more attractive to other members of Congress as well as the administration.
I am reminded here that we have very few minutes left really for questions from the audience. If you could keep your questions very brief, and hopefully the answers very short. Would you take a microphone? I don't know who was here first, but let me start with you first over here.
Congressman Shumway, you show admirable...
Would you identify yourself?
My name is Brant Lee.
Right.
I'm a student here at the Kennedy School and at the law school. You show admirable concern about the backlash, possible misguided backlash against Japanese Americans were this bill to pass. My question is, do you think that the role of public officials should be to give in to and to thereby validate those misinformed opinions, or to sort of stand up for what you really think is right and thereby to educate people who might feel resentment if the Japanese Americans were to attain this bill?
I don't think there's any one standard that all public officials have to abide by in making that judgment. I suppose it's a matter of priorities for each member of Congress. I just happen to have a very great respect for Japanese Americans that I have in my district and I know very well. And they've earned that respect, not just in my eyes, but in the eyes of virtually all America. And now to slip away from that and become an object of criticism is something that I really don't want to see happen. And so it seemed to me like a significant thing to not vote for legislation that would spawn that kind of bias.
Yes. Would you identify yourself?
Yeah, I'm Paul Carlson. I'm a first-year student at the Kennedy School here, and I wonder if you could, Congressman Shumway, give us some more specifics about what you were doing to forestall that kind of prejudice. This is the first I've heard of such a backlash, and I wonder, have you put articles in newsletters? Are you doing outreach? What are you doing to explain to people that kind of anti-Japanese American prejudice is factually incorrect and wrong?
Well, of course, I have influence only in my district in California. I'm one of 435, and I'm hardly going to change the tide of opinion in the nation. But I have spoken many times, as I've spoken here tonight, of my feeling about this bill, my feeling about how wrong it was to do what we did in World War II, how much we owe an apology to these good American citizens. And I have stated that both in writing and publicly several times, but it's going to take more of an effort than that, obviously.
We have very few minutes left, unfortunately. Yes. Would you identify yourself and state your question very briefly?
My name's Hetty Cheng, and I'm here at the Kennedy School. And I'd like Congressman Mineta to address the concern regarding payment to individuals versus the establishment of an educational trust fund, or the majority of the funds going to an educational trust fund, and the utility of that in terms of making this an issue salient to the American public.
Well, as I recall, the original bill was really for $1,350,000,000, but that was cut down because of the concerns that some people had about how much would be available for educational and humanitarian purposes. And so the educational and humanitarian purposes was cut down to $50 million, and those would be used for research by scholars, as well as, let's say, for the establishment of senior citizen homes, for the elderly, for the older Niseis who lost out on their opportunities during their educational and formative years. But that portion was cut down, and the majority of it was still kept for the $20,000, based on the fact that of the 120,000 evacuees, roughly about 60 to 65,000 today are still living. As Mr. Shumway has indicated, there is nothing to go to heirs. These are only to those who survive today from having gone through the evacuation orders. So the vast majority of that money, of the $1,250,000,000, goes to individual payments. $50 million is only for educational and humanitarian purposes.
I guess my concern was, why should it go to individual claims instead of more towards an educational trust fund?
Well, yeah. Go ahead, Grace.
Let me respond. I got the gist of what you were asking. We have to remember that when we went into camps, were not treated as individuals, okay? We were en masse put into these camps. And therefore, we think that individual payments are justified because then we will be treated as individuals. Do you understand what I'm trying to say here?
Dale?
Shumway, I thank you for coming here. I learned a little more about your position that I didn't know before. But I just wanted to correct one misunderstanding I think you do have. You mentioned that part of your position against the bill rests upon the Supreme Court cases which validated the exclusion and curfew in 1943 and 44 when those cases came down. Well, recently in the last few years, you did not mention this, but there have been 3 more cases in which the courts of the federal district courts have ruled that the record in the Supreme Court were fatally tainted. They were a record based upon fraud upon the Supreme Court, that there was no military necessity for Japanese American exclusion or the curfew. 3 of those people won their cases. And using standards that were used in 1940, they held that the Supreme Court received a fatally defective record, in a sense undercut the entire factual basis for those Supreme Court cases. Those Supreme Court cases, in my mind, and in the minds of most commentators, have no life anymore, and as a matter of fact, have never been cited for a discriminatory racial act. So I just want to say there's not much livelihood left in those cases, and to cite those cases in 43 and 44 without citing the newer results of those cases, I think is unfair.
Well, I'm told we only have 1 more minute, and I'd like to, how many questioners do we have? 2, 3? Can we accommodate them at all, or are we going to be able to have to cut it off?
We're going to have a reception at the IOP living room right after this, and so if you have any questions, we'll welcome you to bring it over to the living to ask each of the panelists individually. But I think we'll take 1 more question.
Hi, my name is Eric. I'm a senior here. I'm from Hawaii, and I've never really understood what the government's justification was for the selective internment of people in Hawaii, which was at that time U.S. territory, and the complete or total evacuation of Americans.
The difference in treatment between the mainland and Hawaii. Would anybody on the panel wish to respond to that? Well, to be frank with you, I don't know, but there's obviously some reasons. Number 1, it's economic, money. Because if they uprooted all of the Japanese Americans out of Hawaii, the entire state would collapse. It's simple as that. And I understand, for example, they needed the Japanese Americans there to work the plantations, work the ships, the load and unload. The entire state would collapse and shut down. And yet that was a war zone. Well, I'm going to have to abide by the people running this program. Indeed, we've run over time. There is a reception in the adjoining room. And please feel free to come up and pose questions to any one of the panel members. Thank you all very much.